what does an injured worker need to prove in order to receive compensation under the Workers' Compensation Act in Michigan?
Well, the main thing, and I know you know this because you've practiced many years too, but just for the edification of our viewers, I'll start at the start. The main thing is you have to show a work-related injury, and the way that the workers' compensation law in Michigan phrases that, it has to be an injury arising out of and in the course of employment. That doesn't necessarily mean you have to be within an employer's building. It can be in a parking lot. It can even be while you're traveling for the employer, but it has to be while you're on the job. And that really was the main focus for many years. It still is an important focus. But in the last decade, especially the last couple of years, there's been an added second significant factor of you as the injured worker have to show that there is no other job or very few jobs that you're still able to perform, because the added factor of having to show an actual lessening of your ability to earn a wage has come into play.
So it's become much more like a Social Security Act definition of disability in terms of the extent of disability one needs to demonstrate.
Right. Social Security disability, for those who don't know, is well, this is simplifying it, but you basically have to show you cannot do any work, unless, of course, you fit into some of the other categories.
So in relation to some of the procedural stuff, what would you recommend if an injured worker initially has an injury and doesn't know how to proceed?
Well, if they're in the Battle Creek, Kalamazoo area, certainly they should call Jim Hodsma, who is the best plaintiff attorney in these parts for that. But if you're anywhere else in the state, you might want to look up Solomon Law Firm, although I'm sort of stealing from Jim's jurisdiction because he also goes throughout the state. But certainly one of us would be a good starting point. However, if you're in a shop that has a steward, a lot of times somebody like that is knowledgeable too to help you. As soon as you get injured, you really should latch onto somebody who can help you go through the right hoops. And one of the very first hoops is to report it promptly. You can still possibly be due benefits if you don't report it right away, but then you've just given yourself another hurdle that you'll have to go over later. Promptly reporting, and even with a hesitant employer, employers, once you tell them you have a work-related injury, they have a statutory duty in Michigan to fill out the proper forms. But having been on both sides of this, I know that some employers may even try to talk an employee out of doing so. Let's wait and see how it plays out, they'll say, because they know their workers' comp premium is going to go up if they get a lot of injuries written up. But you can keep insisting. You can keep saying, I need to file that initial basic report of injury. That's really one of the first steps.
How prompt is promptly?
Well, you and I have both been in trials where if it's not the day or the day after, it starts to raise a question of fact, as they call it, about whether it really happened when you say it happened. I mean, people often will wait a week or two because, if it's a small strain in the back, say, they'll wait to see if it gets better. And so it's not uncommon and it's not unrealistic to wait a few days. But really, if possible, if you think it's anything that's gonna last, you should mention it.
So after the employer receives the notice and the employee completes an injury report, say, what does the employer do with that form? Or what is the employer supposed to do with that form?
Well, they're supposed to, if they have an insurer, some employers insure themselves, and of course then they know about the injury as soon as you give them the form. But if they have a separate insurer, they're supposed to give it to their insurer. They're also submit it to the state, and that is supposed to get the wheels in motion for getting the injured worker what they need.
And how does the injured worker confirm that that is being done, that those wheels are in fact being placed in motion?
If you don't get a call as an injured worker within a couple of days from the next stage up, either an insurer rep or sometimes insurance companies don't call you directly, they hire what's called a third-party administrator. Somebody from the third-party administrator should call you, or somebody from work. If somebody's not following up within days, then it's your responsibility, I think, to tell the insurer again to remind them what's going on in your life.
And after that insurer gets that reminder, say, the insurer often sends either a notice of compensation benefits or a notice of dispute. What's the difference between the two?
Well, the insurer or employer have great latitude in Michigan to decide whether to pick up a claim. You can have what you think as an injured worker is very strong evidence or clear evidence, and oftentimes an employer will pay in those situations, but for whatever reason, the employer may have other strategies in their mind, and they may decide to decline a claim that should really be paid. If they're going to decline it or dispute it, there is an official form, as you mentioned, called notice of dispute. If it is accepted as a workers' compensation injury, then the worker will get a form that you mentioned called notice of compensation.
How's workers' compensation wage loss computed?
Well, the law says that your benefit will be 80% of your after-tax wage. But the law also tries to average out what your wage would be so that an employer cannot benefit from maybe a very low week you had, and the injured worker cannot benefit from an extraordinarily high-paying week they had. You are to look at your last year's worth of wages, and you take the highest 39 weeks of those and then average those out. You then plug that number into a formula that the state provides to figure out what the official 80% after-tax amount of that is.
Is there a max?
There is a max, and it changes every year as inflation hikes it up a bit. If your average is above the max, then your weekly benefit will be the max. However, that higher average, the real higher number, can still come into play in other ways in workers' compensation. For example, if you go back to a light job and that pays you a little bit, that is supposed to be, well, your benefit rate at that point is deducted based on the difference between your light duty earnings and what you were earning at the time of injury. You're supposed to subtract the light duty benefit rate from the higher original benefit rate, and in that scenario, you're still supposed to use the higher number.
What about medical treatment? I know that's one of the benefits under the Workers' Disability Compensation Act. How does that work?
There's three basic benefits available under workers' compensation. It was the great compromise struck in many states about a century ago when some workers were filing cases in regular court, circuit court, and employers complained that there were just too many liabilities that could run them out of business. So the big compromise was that workers who are injured on the job have to bring their suit in workers' comp court, not regular court. The law is written so that it's supposed to be easier for them to qualify for benefits than in a regular circuit court, but that their benefits are limited somewhat. And the three basic kinds of benefits are wage loss benefits, medical benefits, and vocational retraining or vocational rehabilitation benefits. So you've asked about the second one, the medical benefits. Even if a worker is not losing wages, I mean, you can imagine a case, say, where somebody has an injured arm, but they're still able to do their work. So they still get to go back to work and earn their regular wage, but they do have to have medical attention given to their arm. If you have an on-the-job injury, whether or not you're losing wages, the workers' comp law says that you're supposed to have the employer or the insurer pay for those medical bills. And you, for the first 28 days after the employer learns of an injury, the employer has the right to tell you where to get that treatment. They get to control your care for the first 4 weeks, 28 days. They often send to an office clinic. And then after that, the worker gets to choose, and they typically will go to their treater or some specialist that's been recommended to them.